Hello all, my name is Harjinder Singh. I've been working with TTC since last 8.5 years. Topic for today's discussion is, can I patent an idea or do I need a product prototype? Generally, inventors think whether they can patent an idea directly or do they need to build a prototype first. The answer to this question is yes, we can patent an idea without any prototype. As per the US patent laws, you need not to have a prototype while filing your patent application. Only thing one must do is to properly explain the invention so that any person having ordinary skill in the art is able to understand, make and use it. According to section 10(4) of Indian Patent Act, every patent application must be accompanied by a patent specification. This section states what must be included in the patent description. A part of the section states that every complete specification shall fully and particularly describe the invention and its operation or use and the method by which it is to be performed, disclose the best method of performing the invention which is known to the applicant and for which he is entitled to claim protection. Depending on the product and the field of technology, one should fully describe the invention and its operation or use and the method by which it is to be performed without building a prototype. In crux, according to the Patent Act, it is not mandatory to have a prototype before applying for a patent. However, in some scenarios, one might have to build a prototype to be able to describe the invention in the required manner. In some cases, the patent office might request for a prototype illustrating the invention. Even in such cases, the prototype will only have to be provided before the patent is granted. The inventor will have sufficient time after applying for a patent to create such prototype. Hence, the inventor need not worry about creating such prototype before applying for a patent if he can describe the invention properly. The relevant section, which is section 10(3) that corresponds to submission of a model or sample, states that if in any particular case, the controller considers that an application should be further supplemented by a model or sample of anything illustrating the invention or alleged to constitute an invention, such model or sample as he may be required shall be furnished before the applicant is found in order for grant of a patent. But such model or sample shall not be deemed to form part of the specification. Now we'll discuss about pros and cons of patenting an idea without a prototype. First we'll cover the pros. So the very first pro is reduces the chances of early publication. If we start working on building a prototype prior to protecting our invention, there is always a risk of someone else getting access to our invention and publishing it without our knowledge. This can happen if we take our prototype online or in trade shows, etc. Second pro is saves money. Building a prototype can be a costly affair. By just focusing on getting a legal protection for your invention, one can save a lot of money. Third is move faster through the patent process. It's a fact that if someone tries too many things at the same time, they might end up doing nothing. So it's better to channelize all your energy, time, money in getting a patent, and this will help you in completing the patent process much faster. Now we'll discuss the cons of patenting an idea without a prototype. The very first con is no customer feedback. The major drawback of not building a prototype is you'll not get any customer feedback or industry feedback. Feedback from potential client is one of the best ways to improve the invention from something that is merely innovative to something that will have a big market demand. Second con is lose insight on improvement. It is important for any investor to improve their invention over time, but if you don't implement your invention, how will you improve it? Building a prototype also helps you come across potential issues with your invention and allows you the opportunity to incorporate improvements. This will help you develop and present a better patent application than you otherwise would have without building a prototype. So the conclusion is, one can patent an idea without a prototype if you can create a proper specification and figures. Filing a patent application without a prototype has some benefit, but there are some cons as well. Overall, it's a good practice to get a legal advice from a law firm specializing in patents on whether filing an application for an invention without a prototype is the best decision for you. That's all regarding the today's topic. Hope you liked it. Thank you very much.